Hi, this is David Bliven, Bronx and Westchester divorce attorney with another episode of Lessons from the Divorce Wars. So this lesson comes in where I've had a few cases like this recently, but a lot of cases over the course of my career, where people launch into especially contested divorce litigation. They start answering disclosure and they show up at their court dates and they're so focused on the litigation, they forget a kind of critical piece, which is settling the case. About 95 to 98% of all divorce matters are going to settle at some point along the road. So you really want to reach out to your attorney, make sure that those settlement negotiations are happening, but don't put the onus on your attorney to initiate that settlement negotiation or to have those settlement negotiations on your behalf. They really can't do that. The best attorneys are going to do those settlement negotiations in collaboration with their clients. In other words, it works better if you have a completely separate appointment with your attorney. You have one appointment for the litigation, you have another appointment to just discuss settlement. You go over each and every issue, kind of in a bullet point fashion. This is what I ideally would like, this is what I'm willing to settle for on each and every issue, so that your attorney is clear. This is kind of your ideal bottom line, etc. Now they know their range on each and every issue. Now, once that's been gone over, now that attorney can get back to the opposing counsel. Now, the stupid attorney is going to go in and say, here's the floor, here's the minimum my client's going to agree to. No. The best attorney is going to go in and say, well, hey, look, this is our trial position. You know, we could come off it a little bit, but we want to hear what your client has to say. You know, if the two people are relatively close, well, then there's not much of wiggle room that needs to be done on settlement negotiations. But if the attorney also knows this is kind of the floor below which I really won't settle for anything lower than that, now the attorney might have authorization for their client to adjust that in the settlement negotiation. Another thing that you can do, set up a four-way settlement conference between the attorneys and the parties. Don't wait until you go through the entire process of disclosure as well as depositions to start thinking about setting up a four-way. You can set up a four-way conference before you even contest the case. You can set up a four-way settlement conference right after the preliminary conference. You don't have to exchange boatloads of disclosure before you get to that point. Now, there's some cases that you need that disclosure to kind of inform your settlement negotiation. So, you know, don't use a cookie cutter approach either. But, you know, it doesn't make sense to me in most cases to wait until the eve of trial before you start having your four-way settlement conference. That part doesn't make sense. So if you're looking for similar answers to questions like these, check out my blog. You'll find it at blivenlaw.net/blog. See you next time.